Hello, everyone. Welcome to this session of Arbitration and Conciliation Act 1996. So, in this class, we will be learning or we will be getting an understanding about the Arbitration and Conciliation Act. See, if you observe now, the JGL syllabus, we have old syllabus as well as new syllabus. But if you take today's session, whatever I will be discussing, it is just I'll be giving you a brief introduction to the Act. So, in old syllabus, we will be studying only about Arbitration and Conciliation Act. But in new syllabus, we a small one more topic is added, that is mediation. Okay, so but in this class, we will be discussing the topics which are relevant for both the syllabus students. So it's not that it's only applicable to new syllabus or old syllabus; it is for everybody. And here, as the arbitration chapter is huge, today I'll be giving just a brief introduction. Kind of you get a brief idea about what arbitration is. What arbitration is, and who are the arbitrators. What is an arbitral institution, council? So these things, in major things we will be discussing in today's class. So with this, let's get started with Arbitration and Conciliation Act 1996. So first of all, we have to understand what is this arbitration, conciliation, or mediation. So first of all, arbitration, conciliation, or mediation is an alternative dispute resolution mechanism. Okay, alternative means, see, there will be so many daily there will be so much of cases that come up or disputes that come up before the court. So for each and everything, if you keep on going to court, what will happen? So court will not have so much of time, and we will also not have so much of time to go to court and get settled each and every dispute also through court. So that is why our Parliament has introduced this Arbitration and Conciliation Act, where, see, first of all, I will clarify. For a criminal case, you can't go to arbitrator or a conciliator. Okay, this is only for civil and business matters. Arbitration is basically for civil and business matter. So conciliation is also, it can be civil, business, or any other, between family, property issue, all these things you can go for conciliation or mediation, all these things. So basically, arbitration is mainly for business matters and civil matters. Okay, not for criminal, not for family matters or anything or personal issues. So for each and everything, whenever you have a dispute, whenever you have a problem, for everything, if you approach court, it is time, it takes a lot of time. So for us also, it is a time waste, and for the court also, it is a waste of time, because the court already it is having a lot of cases, lot of issues to handle. So that is why we are having this out of the court settlement. So that is why we call it as alternative dispute resolution mechanism, ADR, alternative dispute resolution. Alternative means something which is instead of court, alternate. Okay, this is an alternate to the court. So instead of going to court, so you can always approach these arbitrators, conciliators, and get your disputes resolved. So they act like a court only. That means whatever the decision the arbitrator gives, so that is equal to decision given by the court. So you need not worry about it. So legal recognition is there. So it saves your time, and it is more convenient. So you can always, and it is cost effective. So you can always, approach wherever possible. You can make use of alternative dispute resolution, that is out of the court settlement, rather than for each and everything approaching the court. Okay, so that is the brief introduction about what is arbitration. Okay, because without knowing arbitration and conciliation, I mean, just without having any idea about it, if I simply start with the introduction, it makes no sense. So that is why I have told you what is arbitration. So arbitration and conciliation is nothing but out of the court settlement of the disputes, or it can be called as alternative dispute resolution mechanism. Okay, so now with this, we'll see the introduction, when it started, how it started, all these things. So, if you see, the history of arbitration in India commences with Act 8 of 1859. See, it's in the 19th century only. This has started, which codified the procedure of civil courts. So, it gave a procedure for civil court. So that is why now what you have to understand, for criminal cases, you can't resort to this. You have to go through the normal court only. I mean, you have to go through those same procedure. Okay, so all this started in 1859. Then in 1925, so the Civil Justice Committee in 1925 recommended several changes in the arbitration law. On the basis of the recommendation by the Civil Justice Committee, the Indian legislature passed the act, that is the Arbitration Act of 1940. So it started since 1859 only. And in 1925, see, 1859 law, same procedure, same provisions. You can't, keep on following even after years. So in 1925, one committee, Civil Justice Committee, okay, was formed. This committee was formed in 1925. After this Civil Justice Committee, it has, gone through the old act, the prevailing act. They recommended few changes. Okay, these things you have to change. Okay, the same thing you can't keep as it is. So these changes you have to bring in. So, by incorporating all those changes, our parliament has introduced this Arbitration Act of 1940. 1940. Okay, I can't. So this is a Indian legislature. So even before independence. So in 1940 only, this Arbitration Act started. Then the Indian legislature passed the Act, Arbitration Act of 1940. Then, with the passage of time, see, any law you take it, because it needs changes, it needs amendment. Okay. See, we are, as human beings, we are developing and we are introducing new techniques and all those things. So, that is why whichever law we are following, no, it becomes, after few years, it becomes outdated. So, you can't keep on following the same thing. That is why in law, we introduce a lot of amendments, we introduce a lot of changes according to the changing requirements of the people, according to the developments or new techniques or innovations in any field for that matter. We need changes, as in the law also we need changes. So that is why this 1940 act also, see, from 1859, in 1925 one committee was formed, it gave suggestions. So with that we have Arbitration Act 1940. But after a few years, even 1940 act became like outdated. So that also you can't follow. So it became outdated. And the need was expressed by the Law Commission of India. So Law Commission of India, the then Law Commission of India said no, we can't follow the same thing now also. So it's become kind of outdated. And not only Law Commission, various other representative bodies of trade and industry wanted this amendment as to be more responsive to the contemporary requirements and to render the Indian economic reforms more effective. So 1940 Act was okay, good. But the 1940 Act, it's same thing you cannot continue till 1990s, because in 1990s, basically, if you see, liberalization, privatization, globalization, that LPG started, and a lot of businesses started to grow, flourish. So with that old act only, Arbitration Act, you can't it was not convenient for the traders and the business people. So various representatives of the trade and industry, representative bodies of trade and industry, and then Law Commission of India, they said, see, till now it was good, correct? Now we need more updated act. So that is how Arbitration and Conciliation Act 1996 started. So we will see what happened here. So, with a view to mainly to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, enforcement of foreign awards, and also to provide a law relating to conciliation and related matters, a new law called Arbitration and Conciliation Act 1996 has been passed. So, basically, what happened here in 1940 Act, there was nothing like conciliation. See, basically, conciliation, arbitration means it is a bit kind of, what do you call, more strict. Okay, arbitration is kind of more, the procedures are strict. Conciliation is very informal. Okay, so I can't say strict, it is formal. Arbitration is more formal, but conciliation is more informal. So that conciliation concept itself was not there in 1940 Act, but in 1996 that was introduced. And if you see, in 1940 Act, there was no much importance given to international commercial arbitration and all. Why international was not considered? Because at that time In our country, people were not going outside India and doing business, nor other people, other countries people were allowed here come and do the business. So that was actually not possible. It was not happening. Not it was not like not possible. Our government wanted to protect our industries, our business people, all these things. So uh, due to so many things, or with so many objectives, so there was no much import export or foreign businesses which was happening in India. But later, after this LPG, so our country people started going to other countries and start the business. They came here and they started investing in our country. So all these things started. Now our only Arbitration Act of 1940 started becoming, are outdated. So that is why in 1996 Arbitration Act, they brought in the concept of international commercial arbitration also. That means if I am doing business, see, for example, I am Indian. Okay, I am doing business with a USA person. We both have entered into a contract. Now there is some dispute with respect to the contract or the deed agreement, whatever you call it as. So there is some dispute. Now we want to resolve the dispute. So for that, instead of going to court, we know we have this Arbitration and Conciliation Act, wherein we can meet an arbitrator, or we can refer this case to the arbitrator and get it resolved. Correct. No, so that we know. Now, in in this situation, what happens? So now, if I am doing a business with a person who stays in USA, and now we are having a dispute, this is called as international commercial arbitration. Commercial only. Commercial means business related. And international. So one person is Indian, another person is abroad. So now this is international commercial arbitration. So now we refer the case to arbitrator. That becomes international commercial arbitration. And enforcing foreign arbitral award. Award means arbitrator's decision is called as award. Okay. What is an award? Award is nothing but the arbitrator's decision. Okay, that is called as an award. So foreign award means, so I will go to a foreign country and get the arbitral award. So get my dispute resolved. So that how to apply here. Here also I have to come and follow, no, something written in the foreign arbitral award. So what needs to be done with respect to that? So all this was incorporated in 1996 Act. So the new law is mainly, based on the model law. So every, this one, even our Information Technology Act, if you see, it's all based on United Nations Commission on International Trade Law. Okay, that was like a model law on international commercial arbitration. So that they have considered, and that something we need to refer. No, before writing something, before drafting a law, we want some reference. For that, we have taken this UNCITRAL model. Then the Arbitration Conciliation Act 1996 aims at streamlining the process of arbitration and facilitating conciliation in business matters. So they also see this streamlined the arbitration. That means something which was not covered in the arbitration, whatever was more updated things were required in the Arbitration Act, that was also incorporated. Plus, they introduced a new concept called that conciliation also. So again, see, with the passage of time, some difficulties were noticed in applicability of 1996 Act also. Okay, see that 1996, at that time it was very much updated, but now with the passage of time, even that we start feeling little, kind of outdated. Now, why it became outdated? Because the interpretation of the provisions of the Act by court in some cases have resulted in delay of disposal of arbitral proceeding, an increase in interference of the courts in arbitral matters, which tend to defeat the objective of the act. See, basically, 1996 Act, when it was introduced, that time it was very it was good, it was updated. But later, what people started feeling is, see, even though that was the main problem in 1996 Act. So even though you get a what do you call? You get a award from the arbitrator. Okay, arbitral award you have got. Still, court interference was there. It's like some complicated things that has to be solved by court only, or maybe you have to get even though our award has been passed by the arbitrator, you have to get approval from the court, something like this. In one way or the other, court used to interfere with the arbitrator decision. You are going to an arbitrator, you are getting the case solved, resolved, or dispute resolved, all these things are happening. Still, court is also interfering. This court interference, actually, we don't want. No, we are going to arbitrator to save our time. We don't want the court interference. Again, we don't want to go through those kind of tedious process and all those things. That is what we are trying to avoid. But again, if you have to interfere, when court interference is there, means people started to feel somewhat the objective itself is not achieved. Correct? No, we are going to arbitrator also. Again, court is also interfering. Somewhat the objective is not properly achieved. This is what people started to think. So, so they wanted more, kind of updated version of Arbitration and Conciliation Act 1996. So, to overcome these difficulties, now we have Arbitration and Conciliation Amendment Act of 2015, and then this Amendment Act facilitate and encourage alternative dispute mechanism, especially arbitration for settlement of disputes in a more user friendly. See, arbitration is there, but it is 2015 Act made it more user friendly, cost effective, and less time consumption, expeditious disposal of cases. So, see, expeditious disposal means you are working efficiently plus you're fast. Okay, you're fast plus you're efficient. See, sometimes what happens, when you're doing something, some work, uh, if you want to complete the work fast, what you will do? So you will not concentrate on the quality. You will not be efficient. But if you want to be too, very efficient, then your work will slow down. That should not happen. Always it should be expeditious. Expeditious means you are being efficient also, you are doing your work properly and you are doing it fastly. That is expeditious. So, expeditious disposal of cases, since India is committed to improve its legal framework to obviate in disposal of cases. So, though arbitral institutions have been working in India, they have not been preferred by parties who are in favor of ad hoc arbitration or arbitral institutions located abroad. See, we have many arbitral institutions in India, but people are not preferring arbitral institutions. Okay. See, arbitral institution means that is one institution where you find a lot of arbitrators who are in that institute, working in that institute, or those who are associated with the institute. So that institute will help you in um, appointing the arbitrators for you and settling the dispute. But even though these institutions exist in India, people used to refer the cases for ad hoc arbitrators, or they used to go abroad. Okay, so this is used to happen. Ad hoc arbitration means no institution, nothing. See, I will come to you. You know the topic. You know my, dispute. You know our dispute. I will tell you. Okay, you only solve the dispute. You become my arbitrator, like that. Okay, you are an expert in that subject. It's not that I will not go to some illiterate person and tell become my arbitrator. It's not like that. Okay, see, I will go to my company secretary and I will tell him, see, I was you, I have appointed a company secretary, so I will go to him and I will tell, see, this is a dispute. I mean, now we are having a partnership firm. In this, this is a dispute. You solve and give an arbitral award. So this is ad hoc. Okay, no, they are not associated with any institute or anything. So that is because that is more. If you go to institute, is more costly. Ad hoc is good, but if you really want to go to institute and get your dispute resolved, people used to go to abroad, foreign countries, and get their dispute resolved. Okay, that means Singapore, London. So there they used to go to arbitrator and get their problems resolved, disputes resolved. That means what? People somewhat they were not convinced, or they're not happy with arbitral institutions in India. They don't want, because there is no proper recognition for them. I don't know which institute is good. There are many institutes. Okay, I don't know which institute is good. So what I will do, instead of going to institute and paying high fees and getting one arbitrator appointed and getting my dispute resolved, instead of that, I will only go to some ad hoc arbitrator. I will take his help and I'll get an award. That is better, no, cost effective. Or if I really want an arbitral institute, why I will go to Indian arbitrator? I will go to foreign, some other country like Singapore. It is very famous, and London. So there we will go and go to arbitral institute and get arbitrator appointed, get the problem resolved. So this used to happen. Therefore, then our country realized that okay, people, even though arbitral institutes are there, people are not going to it. Why? What is the problem? So now they identified and they formed a committee. Okay, for that they formed a committee with the chairmanship of Justice B.N. Sri Krishna. That's a former judge of Supreme Court of India. So he was a former judge of Supreme Court of India, and this high-level committee submitted its report on 30th of July 2017. See, that is our parliament, our government. Everybody understood that even though arbitral institutes are there, people are not going to it. Correct? Why? What is the problem? So they formed one committee with Justice, B.N. Sri Krishna. So he was a former judge of Supreme Court of India, and that committee submitted a report. So in that report, what they said. So if you want to strengthen your arbitral, institutes or the whole procedure, arbitration procedure in India, you have to form one, you know, council. Okay, you have to form one council. So who will be heading all the arbitral institution? So that is like with the view to strengthen institutional arbitration in the country, the said committee recommended for the establishment of an independent body for grading the arbitral institution and accreditation of arbitrators, etc. See, that means, just a second. See now, see, this happens now. We are having arbitral institution. Okay, we are having arbitral institutions. Lot of arbitral institution. With them, arbitrators are associated. To select which institution is good, which institution is not good, how will you know? So that is why what people used to do, we will not go to arbitral institution, we'll just go to some select individual arbitrator, we will get the dispute resolved. That is better, no? So people used to do that. That is why the institutional arbitration was not at all developed in our country, even though you brought in so many changes. That this was not, people, if you want arbitral institution, people used to go abroad only. Then this committee told, no, you establish, one body that is like that is called as Arbitration Council of India. Okay, that is this, one body. So this arbitration council will be taking care of all the arbitral institution 1, arbitral institution 2, arbitral institution 3, like that. Many arbitral institution in them, and they will also have accredited arbitrators. Accredited arbitrators. So what is this accredited arbitrators? That means, see, now I will tell you, we have ICSI, correct? No, institute. So that institute, it will give us a syllabus. So this exam you have, this is your syllabus. So you have to study this. You have to pass this exam, and then you will, pass this level. After that, you go to final, and then this subject you have to study, and then you pass. Then you become a qualified company secretary. So this institute is there. So institute, whatever it says, according to that, various we have, the academies who teach according to the syllabus given by the institute. See, like first is our ICSI. Under ICSI, now at Excel Academy, we know, so okay, this is the syllabus of ICSI. So now like this, according to this syllabus, we will teach. Then you will come and learn with us. Otherwise, what will happen? See, if this ICSI itself is not there, every institute or every coaching center is giving you CS certificate means, will it have any value? Does it give you any value? It doesn't know. So every coaching institute, Excel Academy will give CS certificate. Some ABC Academy will give CS certificate. They will, however they want, they will conduct, according to their whims and fancies, they will conduct exam. This will not make sense, no? So one head should be there. Who is that head? Our Institute of Company Secretaries of India. So they will give all the, formats or all the syllabus, everything, one overview or broad framework they will give. Within that, we will function, and they will conduct the exam. Same manner for arbitration also, one arbitration council should be there. That council will take care of various institutes, arbitral institution. there are so many arbitrators, let them, we will give them exam, let them arbitrators write the exam and get the membership number. Let them, how with institute you get in membership number, once you qualify you become member of the institute and you get that unique membership number. In the same manner, let the arbitrators take exam, and then get a membership number, associate with that council. So all these things should happen, then only people will prefer. So this is what the committee told. And the committee was also recommended certain amendments to the said act to minimize the approach of to minimize the need to approach the courts for appointment of arbitrators. See, for appointment of arbitrators, many times we used to approach the court, so that also should be reduced. So those amendments also our committee told. So by keeping in view all this, in mind, no Parliament passed again Arbitration and Conciliation Amendment Act in 2019. Okay, so now we will see some types of arbitration. First one is ad hoc arbitration. So ad hoc means I already told you. So this is a type of arbitration where you don't have any, kind of arbitrator who is taken care by any institute or they are associated with any institute, nothing like that. So it is very informal. So this is a type of arbitration which is not handled by a formal organization. Rather, the number of arbitrators, mode of selection, how arbitration will be conducted may be decided by the parties. So I told you, you are a company secretary, you have expertise in the dispute. So I will come and tell you, see, we will only sit and decide. You be my arbitrator, you be our arbitrator, you help in settling a dispute. That's all. So we are not going to any institute or organization to get the dispute resolved. So that is ad hoc. Domestic means arbitration disputes, which is settled between two people who are staying in India only. Okay, no foreign country business or anything is involved here. So the arbitration in which the disputes are subject to Indian laws and the cause of action entirely everything is based in India. So that is called as domestic. International, I have already explained. Then institutional arbitration is, see, in institutional arbitration, all the matter is to be administered by established arbitral institutions. So arbitral institutions will be established and they will have a panel of arbitrators, and that institute will decide how procedure should be conducted, when which dispute, which arbitrator should be appointed, mode of settling the dispute, everything they will decide. So that is institutional arbitration. Okay, next we will see what is an arbitration. Okay, so section 21A of the Act defines the term arbitration, which means any arbitration, whether or not administered by a permanent arbitral institution. See, arbitration means it is just a dispute resolving mechanism which is related to civil matters and commercial matters. Civil and commercial. See, these two things you have to remember. It should be civil and it should be commercial. So arbitration is just that, you're solving the dispute. It can be through an institution which is established or just an ad hoc arbitration. Both are okay, whether or not administered by a permanent arbitral institution. Okay, so now we will understand the term who is an arbitrator. So the term arbitrator is not defined. See, you don't get any definition. If you see Arbitration Act, you don't get any definition who is an arbitrator. But the arbitrator means a person who is appointed to determine the differences and disputes between the two or more parties by the mutual consent. So he's a person who is appointed mainly for what purpose? To resolve the dispute of two parties. And they, how they have appointed this person? Mutual consent. Okay. See, now I and you are having a dispute. Okay, we want to go to arbitrator. If I want to go to arbitrator, but you only want to go to court, you don't want to go to arbitrator, then this will not work. Okay, mutual consent, then only arbitrator can be appointed. So he is a person who is there to resolve the dispute between two people. Okay, we are having dispute, he will resolve, but we are appointing him with a mutual consent. That means we are going for arbitration with the mutual consent. I should also agree for arbitration, you should also agree for arbitration. So the person who is so appointed, I mean, we are appointing a person as an arbitrator, he should give his consent to act as an arbitrator, and his appointment is not complete till he has accepted the reference, and he must be completely independent and impartial and absolutely disinterested. That means when you are appointing, see, we both decided that we will appoint A as arbitrator. Okay, it is not just our decision. A should also agree to become an arbitrator. So he should also give in writing that I will be, accepting this appointment. I will be consenting for this appointment. So if he doesn't say yes, if he is not interested to be appointed as an arbitrator, then his arbitration appointment is not valid. So mutual consent, as parties, we should also agree. Plus, that person who is appointed as arbitrator, he should also give his consent. Otherwise, it's not just our decision. He should also agree to act as arbitrator. He should be completely disinterested and impartial. That means he should not be like, my friend appointed as arbitrator, he will just give decision according to my favor. Whatever is whatever is required for me, that kind of decision only he will give. That should not happen. He should not be interested at all. In the case, he should not have any kind of interest or towards the parties, nothing. He should not be partial at all. Okay, so if you have appointed a person like my friend, 10 years back he was my friend. Now I have appointed him as arbitrator. Now what happens? So any interest either in one of the parties or in the subject matter which is unknown to either of the parties or all the parties as the case may be is a disqualification. So such disqualification applies only in case of a concealed interest. That means, see, first of all, when you're appointing an arbitrator, he must be completely impartial and disinterested. Okay, he should not be interested. Okay, but even though you have appointed him as an arbitrator, he is interested, he should give a declaration. Okay, he should tell, see, I was his friend, I was his classmate, like that, he should tell. If he doesn't do it, if he hide that, then it becomes a disqualification. We can remove him. And the parties may appoint whomsoever they please to arbitrate on their dispute. So it's not that you have to appoint this person only, that person only. Whomever you want, you can appoint. So usually parties appoint themselves, they will appoint the arbitrator or arbitrators. In certain cases only, court will appoint an arbitrator. See, usually court will not at all interfere. You yourself can decide whom to appoint as arbitrator. In some cases, if required, court may umpire. That means court may help you in appointing the arbitrator. We will see when, what, all these things. Next, we will see arbitral award. Arbitral award includes interim award. That's all is the definition. 2(1)(c) says arbitral award includes interim award. So what is first arbitral award? See, arbitral award means, as I already informed, arbitral award is a decision of the arbitrator. Okay, decision of the arbitrator. That is arbitral award. So some features of the arbitral award we will see. So, what are the arbitral award for features of arbitral award? First of all, an arbitration agreement should be in writing. Similarly, a reference to the arbitration and award is also required to be in writing. The arbitral award is to be made on a stamp paper of a prescribed value as applicable in the place of making the award and in writing. See, first thing is arbitration agreement. Agreement means what? Now I and you are the parties. Okay, we are having a dispute. Now we want to go to arbitrator. So for that we have to have an agreement. That means I have to write, we let us go for arbitrator, or we will go and resolve our dispute through an arbitration agreement, through an arbitrator procedure. You also should say, okay, now we have to enter into an agreement. That means in writing. If I simply call you and tell we will go to arbitrator, and if you say, okay, that is not allowed, that is not valid, we both should have an agreement in writing. In the same manner, once we have the arbitration agreement, we will appoint arbitrator. No, he will pass a decision that is called as an award. That award, whatever he will pass, that also should be in writing, and it should be on a stamp paper. So how much value, all these things will be decided. See, because stamp act varies from one state to another in India. So depending upon which place you are making that award, what kind of award, so stamp duty will be determined. So, but it should be on a stamp paper and it should be in writing. And see, award should be signed by all the arbitrators of the arbitral tribunal. However, signature of the majority of the members of the tribunal is sufficient if the reason for any omitted signature is stated. That means one more thing what we have to understand is how many arbitrators can be appointed. Okay, the next question is how many arbitrators you can appoint. So we can actually appoint any number of arbitrators, but the thing is it should be always an odd number. It should not be an even number. Okay, you can appoint any number of arbitrators, no problem in that, but it should be always an odd number. Like you can appoint one arbitrator, you can appoint three, you can appoint five, like that. So, but it should be always an odd number. Why odd number? Because the decision of the arbitrator, see, if there are two arbitrators appointed, okay, two arbitrators are appointed. Now, one arbitrator say yes, another arbitrator say no. So, what kind of decision can you pass? Not possible, no? So if you make it as an odd number, then the majority decision you can arrive at. Two are telling yes, one is telling no. Decision will be yes. Two are telling no, one is telling yes. Decision will be no. So like that. That is why always you can, any number of arbitrator you can appoint, but it should not be an even number. So now in this case, assume I have appointed three arbitrators. Okay. See, assume I have appointed three arbitrators, that is A, B, C. Now, in an arbitration award, arbitral award will be there. No, that should be signed by all the three. But assume B is not accepting for the decision. A is telling yes, C is telling yes, but B is telling no. Now B need not sign. Only A will sign, C will sign. B's signature is not there. You give us disclaimer telling B has not signed because he is not agreeing for this decision, like that. Okay, so that is what it says. Okay, majority can sign. So the award to be signed by the members of the arbitral tribunal. However, signature of the majority of the members is sufficient if reason is given for the omitted signature. And now every arbitral award should contain the reason. Okay, award should contain the reason. That means if I have passed some award, like I am telling you, the A is right, B is wrong. Why? What have I done? What investing? What procedures I have conducted? Okay, all these things I have to tell, and then at the end, after all these procedures, I uh, you know pass an award or I give a decision that A is right or B is right. Like that, I have to give decision for, I mean, reason for my decision. So without giving reason, simply I can't tell my arbitral award A is right. A has to pay B 10,000 rupees. I can't do it. Why I have arrived at such a decision? Why my conclusion is like this? That I have to give the decision, I mean, reasons for decision in writing. Only two exceptions are there. Under two exceptional circumstances, I need not give the reason for my decision. What are those two exceptional circumstances? First one, where arbitration agreement expressly provides that no reasons are to be given, or where award has been made under section 30 of the act, that means settlement. See, first one is in the arbitration agreement, we parties only decided and we have written in the award, we don't want reasons. In agreement only we have written, we don't want reasons. Okay, then not required. Or maybe settlement. Settlement means, okay, we have gone, I and you are having dispute. Okay, we have gone to arbitrator. We have given the problem to me. We have told him the problem. But before he passes a decision, we have only compromised and settled with our by among ourselves. We have only settled. And we have told the arbitrator, see, this decision we have only arrived at. That means arbitrator has not given the decision. We are only telling arbitrator, see, it's okay. We don't want to continue the procedure. We are okay. We will share 50-50. Whatever money has come, we will share 50-50. You don't worry. So same thing, arbitrator will write it in the award and he will tell they have settled the cases by themselves. So this is the award. This is the final result. The arbitrator has not given decision only. Why he will give reason? Why he should give reason? Correct? No, it is not his decision. In this situation, arbitral award does not require any reasons for the decision. So first one, in agreement, you have only written no, decision needs to be, no reasons for decision needs to be provided. Or if it is done through a settlement, then no, then it's not required. Okay, reason for decision is not required. Next. Okay, so next we will see award can be divided into four parts. See, this arbitral award can be divided into four parts. So first one is general. Okay, it's a general one. Then for general, findings of the fact, then submission of the parties and conclusion. See, first one is in general, this person A is a party, B is the party. So those things, information. Then findings of the fact. Actually, what is the dispute? Then what submission parties? What are the details they have submitted? Then the conclusion. So like this, it has to be divided. That is when you are writing an award, it should be divided into four main parts. That is, in general, you have to give information about the parties, and then findings of the fact, and then what. Evidence A has submitted, what evidence B has submitted, and then what is my conclusion. So the tribunal should explain its view of the evidence and reasons for its conclusion. So everything you have to explain the reason. See, these things they have submitted to me. I have conducted this procedure. I have taken expert opinion. So like this, all the things, whatever work you have done, everything you have to explain, and then you have to tell based on all these things, I have arrived at such a decision. Okay, then the preamble of the award may contain reference to arbitral agreement, constitution of the tribunal, and first thing is you have to write about the parties, then arbitration agreement when it was entered into by with between whom it was entered into, and how arbitration is constituted, tribunal is constituted. Arbitral tribunal can consist of one arbitrator or three arbitrators or five. So everything you have to, that you have to mention. And then later you have to mention about what is the issue, what is the argument of the claimant, argument of the respondent, everything you have to mention. Then arbitral award, it should be dated. See, date and place is very much required, because date and place is required. Why? Because if you are not happy with the decision of the arbitrator, you can always next. See how we go for an appeal. No, if you are not happy with the decision of one court, you go on an appeal to another. In the same manner, if you are not happy with the decision of an arbitrator, you can always go to the court and you can ask to set aside the award. Set aside means setting aside of the, it's called as setting aside of the award. Setting aside of the award means cancel this, I don't want to follow, keep it aside and give me a different judgment. Okay, give me another judgment, like that. So to take that action, recourse, time limit will be there, like 60 days, 90 days, all these things, time limit will be there. So in order to calculate the time limit and which court is having the jurisdiction, so in order to understand that, you have to write place and date. That is requirement. Then the arbitral tribunal may include in the sum for which award is made, interest up to the date, and also the direction regarding future interest. See, when you are writing an award, usually it will be related to money. A should pay 10,000 to B, or B should pay 10,000 to A, like that. So in that you can write how much money should be paid and what is the rate of interest, and if any future interest. That means like you have to pay within 6 months, means sixth month I will pay. Next, after 6 months I will pay. So for 6 months also in future, that interest will also be added. So these things you can write it in the award. And the award may also include decisions and directions of the arbitrator regarding the cost of arbitration. See, for conducting the arbitration, cost you have to incur, no, as an arbitrator. Sometimes you may have to take expert opinion, all these things. So that also you have to include in the award. And then after once award is made, your arbitrator should sign and he has to send a copy to both the parties. And because either it will be implemented as it is, or they can go for setting aside of the award. Next we have arbitral institution. So arbitral institution means it is an institution which is recognized. Okay, designated means it's something which is recognized either by a Supreme or High Court. An arbitral tribunal. Tribunal means it is a sole arbitrator. See, one person you appoint as arbitrator, he is also called as an arbitral tribunal, or a panel of arbitrator. Three arbitrators you appoint. That is also arbitral tribunal. So it can consist of sole arbitrator or a panel of arbitrators. When you appoint an arbitrator and you go and give him a dispute, that is called as arbitral tribunal. That's all. Then arbitration agreement is as per section 7. So we will understand what is an arbitration. See, arbitral award we have understood. Award is decision of the arbitrator. Before going to arbitrator, you two parties should have an agreement, no, arbitration agreement. So what is that arbitration agreement? Now we will see this. So, the arbitration agreement has been defined to mean an agreement by the parties so to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of defined legal relationship, whether contractual or not. So we will do section 7 and 8. Okay, so that will be your introduction for arbitration. So in this section 7, that is arbitration agreement says, see, always you should have an arbitration agreement in writing. Okay, so it is not that I told I'll make a call, I will tell you we will go to arbitrator, we are having dispute, and you say yes. That is not an arbitration agreement. So in an arbitration agreement, what basically you write is, you write like, for example, see, there are two things you have to understand here. See, first one is dispute already started, or future dispute. So there are two things here. One is dispute has already started. That means we we did not think of arbitration or anything. Okay, we were doing our business, but now some dispute has started. Now we want to, instead of going to court, because we know this is a defined legal relationship, like a partners. Okay, we both are partners. So it's not family issue or a personal matter. It's a legal relationship. That means we are legally, we are, through law we have become, we have got this relationship. That means like partners, or maybe contract, we have entered into some contract, all these things. So now we are doing the business since 10 years, but now some dispute has arisen. Now we have decided that we will go to arbitrator. Before going to arbitrator, we will prepare one agreement, we both will sign, and then we take that arbitration agreement, give it to the arbitrator, and he will start the procedure. That is, dispute has already started. When dispute started, we entered into agreement, and then we appointed the arbitrator. Okay, that is also fine. Or sometimes what happens, when you enter into the contract, any contract for that matter, you take, terms and conditions will be there, correct? And a contract means a lot of terms and conditions will be there. In that terms and condition, one term or one condition, what we will write is, in future, if there is any dispute, we will refer the dispute to arbitrator. Instead of going to court, we will go to arbitrator. Like this, if you mention it in the contract, one just a small clause, if you mention that, as I know, in future, now as of now, we don't know what the dispute is. We don't even know whether the dispute will arise or not. That also we don't know. But in future, if any dispute arises, we will go to arbitrator. Like this one clause, if you write, that itself will act as an arbitration agreement. So once the dispute arises, then you decide and go, that is also okay. Or before that only you write, for future dispute, one clause you write and keep it, that is also okay. But in any case, arbitration agreement should be in writing. Okay, so now we'll see. An arbitration agreement may be in the form of an arbitration clause in a contract, or in the form of separate agreement. Both are allowed or both are accepted. An agreement shall be in writing. Then it should be in writing. If it is contained in a document signed by the parties, see, when it is considered as a valid arbitration agreement. It can be an agreement or a document which is signed, written and signed by both the parties. Okay. Or it can be an exchange of letter. See, I will send one letter. It should be in writing. Okay, oral not acceptable. But if you send an email or a telex or a telegram, any electronic communication means something in writing, email. Okay, see, WhatsApp and all will not be accepted, but it can be an email or exchange of letters, telex. So that is also okay. So I say we will go to arbitrator, and you say yes. That will only be considered as a arbitration agreement. Or it can be an exchange of statement of claim and defense, in which the existence of the agreement is alleged by one party and not denied by the other. That means, see, specifically, we have not entered into any kind of agreement, like, we will go to arbitrator, all these things we have not written. But I have sent a claim. I have to receive 10,000 from you. And you are telling, no, we have, I have already paid you. But in that 10,000 claim, I have also mentioned, so if you are not agreeing, we will go to arbitrator. You are not denying it. You are not denying it. Then that itself will act as a arbitration agreement. So arbitration agreement means one separate stamp paper you take, you write, not required. In a contract, one clause if you mention also, that is okay. So even a clause of a contract, that in future if there is any dispute, we will go to arbitrator. That itself is sufficient. Okay, then next we will go to section 8. So this will be the last section for our discussion and an Arbitration and Conciliation Act and introduction. Okay, so section 8, what it says is power to refer the parties to arbitration where there is an arbitration agreement. This means, see now, see, A and B have entered into a contract. Okay. In this contract, one of the terms is that if there is any in future, if there is any dispute, we will go to arbitrator. This they have already written. That means what? They are having an arbitration agreement. Agreed? They are having an arbitration agreement. Okay. Now, and we are having a dispute. Okay, they are having a contract. There is having a, they are having a proper arbitration agreement. Now they are having a dispute. What they should have done when you are having an arbitration agreement, you have to go to arbitrator. But B directly went to a civil court and filed a case. Went to a civil court and filed a case. Now, court will not know whether you are having an arbitration agreement or not. Court will take up the case. Now, what A should do? If you are already having an arbitration agreement, A should immediately, whenever A get the summons or notice from the court, immediately in response, we will file a response. No, immediately A should go and tell the court, show the arbitration agreement and tell the court, please refer us back, send us back to arbitrator. We don't want you to settle the case because we are already having an arbitration agreement. This right every party is having. That means in spite of, that is a very simple section. Okay, so it says in spite of having a valid arbitration agreement, if one of the party goes to court instead of going to arbitrator, the other party can always claim and his right and tell the court, as we are already having an arbitration agreement, please refer us back to arbitrator. For this, you have to take an action. That is, A should take an action as soon as possible. See, once the court passes the decision or at the end, maybe after 1 year, if I go and tell the court that we had already arbitration agreement, then nothing can be done. So immediately, because before court take any steps or before court passes any order, this person, another party, should go and give the hint to the court that we are already having an arbitration agreement. Once the court comes to know, because we have to give the original arbitration agreement or at least copy, and if original is with another party, he should tell, see, with this is the copy of the original, so this original is with me, please ask. Then court will pass an order to submit. Court, if the court comes to know that you are having a proper arbitration agreement, then court will not take up the case. Court will tell, okay, you go and settle with the arbitrator only, I will not give the decision. That is the power to refer parties to arbitration when there is an arbitration agreement. So when a judicial authority is brought before the matter, one second. When a judicial authority is before which an action is brought in a matter which is a subject matter of an agreement, arbitration agreement shall, if a party to the arbitration agreement or any person claiming through him or under him, if any party, if they apply that not later than date of submitting his first statement, that means whenever first you have to appear in the court, no, that time you have to tell. Okay, that notwithstanding anything contained in judgment, decree, or order of Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. That means, see, for example, for a criminal case, if I write, I will, I have done a murder, I will go to arbitrator. This is not a valid arbitration agreement only. But, or maybe for any reason, if any high court or Supreme Court has told, no, this cannot be settled through arbitration, you have to go to normal court only. Then, okay. Otherwise, if you are having not all these things, in otherwise normal circumstances, the proper arbitration agreement, if you are having, you can always ask the court and tell the court that, see, this party has applied and he has filed a case in the court, but actually we are having an arbitration agreement and we will go to arbitrator. Court will support you. So the application for reference shall not be entertained if it is not accompanied by original agreement or duly certified copy. See, simply if you tell court, tell the court that we have arbitration agreement, court will not agree. Okay, you should give original or at least certified copy. And it may be noted that where original arbitration agreement or a certified copy, so if it is not available with the party, okay, if you are not having only, then and the said agreement or certified copy is written by other party, see it is with the other opposite party, then the party so applying shall file an application along with the copy of the arbitration agreement and a petition, praying that the court shall call upon the other party to produce original or a duly certified copy before the court. See, you are having just one Xerox copy, okay, not duly certified, not original. Then give that copy only, and also one more application you write where you are requesting the court, this duly certified or original copy is with that party. Okay, please take it from him. Then, if after all these things, if court finds that whatever you have told is right and you are having a valid arbitration agreement, plus this particular issue is valid for arbitrator to handle. Okay, he is having the power to handle. It is genuine and it is arbitrable issue. Then the court will send you back to the arbitrator and court will not continue with that case. So, notwithstanding that an application has been made for reference and that issue is pending before the judicial authority, arbitration may be commenced or continued and an arbitral award made. Okay, so with even though this issue is pending with the judicial authority, and if you are having a proper arbitration agreement, you can commence the arbitral, proceedings. So that can be started. So with this, we will end today's session, and I hope you have got an idea, brief idea about the Arbitration and Conciliation Act 1996. Thank you.